Hello, everyone. I'm Rod Smolla, the president of Vermont Law and Graduate School, and welcome to this forum on the upcoming election and some of the legal issues surrounding the election and the presidency. This program has qualified for 1 hour of Vermont CLE credit. And so if you happen to be watching this as a person who would like to claim credit in Vermont for CLE, please email the chief of staff here at Vermont Law and Graduate School. Her name is Sue Folger, and the email address is sfolger, S-F-O-L-G-E-R, at vermontlaw.edu. And we will then record your attendance and also provide you with written CLE materials as a backup to the lecture. So for those of you attending for that reason, or simply attending because you're interested in the topic, I am going to talk for a fair amount of time, and it's possible that I'll take up essentially the entire hour. If you do have questions you want to pose to me, I've got two different screens on my computer here, and I can see if you put in the YouTube chat, I can attempt to keep up with those questions and answer them. But I'll tell you, I don't think I'll do that until I'm done with the entire presentation. And as I said, if it turns out that we're too rushed at the end for much in the way of questions, I'll be happy if you'd simply email me to answer questions for you. And my email is very simple. It's rsmolla@vermontlaw.edu. So what I want to do is talk about 4 Supreme Court cases that bear on the presidency and bear on the election. 2 are cases from just the last few months, so cases from the most recent Supreme Court term. First, Trump versus the United States, which is the very controversial decision the court rendered on the last day of the term regarding the degree of immunity from criminal prosecution that a former president has for actions taken during the presidency. Secondly, I'll talk about a decision from March, a decision on March 4, Trump versus Anderson. This is the case involving Colorado's attempt to bar Mr. Trump from the ballot on the theory that he engaged in an insurrection, disqualifying him from being fit to serve as president under Section 3 of the 14th Amendment, the so-called Insurrection Clause. And then I'm going to talk about 2 other cases that are a little bit older. One, a case from 2020 called Chiafalo versus Washington, which deals with the really intriguing and potentially quite disruptive problem of what's known as the faithless elector. These are persons who are elected to the Electoral College within a state, but then vote for someone other than whom the voters thought they would be voting for. So we'll talk about that problem of the faithless elector and where that stands. And in a very close Electoral College vote, if it were to be such a thing in this current election, 1 or 2 faithless electors could flip the result of the election. So we'll be talking about that. And finally, I'm going to talk about one more case from just 2 years ago, a case called Moore versus Harper, which was actually a gerrymandering case involving allegations of racial gerrymandering and political gerrymandering, but which also decided a very, very important issue known as the question of the independent state legislature, which goes to the federal electors and elections clauses, and also can have a profound effect on the election by describing the extent to which state legislatures do or do not have exclusive authority to determine the electoral vote processes for a particular state. So those are 4 cases, and I'll spend a lot of time on that first immunity case, which of course has been enormously controversial in our society since it was decided, but also the other 3 cases. And I think as a basket of 4 cases, they provide a lot of background of that may be interesting to you as citizen lawyers and citizens as you contemplate the next election. So let me talk first about Trump versus the United States. The background here is that the federal special counsel, Jack Smith, who was appointed by Attorney General Merrick Garland, indicted former President Trump for a series of actions that, in combination, were all designed to prevent Joe Biden from assuming office as President of the United States and instead secure the election for President Trump. And the indictment in its original form, and I'll talk a little bit later about its new form because a newer version of the indictment has now been filed, essentially accused Mr. Trump of engaging in various forms of fraudulent and corrupt activity to try to upset the election on of 2020. And these included such things as pressuring the United States Justice Department to issue fraudulent letters to various state entities to try to convince those states that there had been election fraud and therefore they should not certify votes for Mr. Biden. It included pressure by former President Trump while he was in office on various state officials to try to convince state officials either to alter the vote count within a state, or to present to the Electoral College an alternative vote of electors that would cast their votes for Mr. Trump and not for Mr. Biden. It included pressure on Vice President Mike Pence to try to convince Vice President Pence that he had the authority himself in presiding over the counting of the votes on January 6th, to make the decision as vice president that certain electoral votes would be counted and others not counted, and to take and to count on behalf in certain critical swing states the alternative slate of electors that had been presented. And it included conspiring with others to create what a lot of people have nicknamed false electors, Confederate electors that were not lawfully elected within states, but had been through various schemes instead put forward as alternative electors that would cast their votes for Mr. Trump. Former President Trump, argued that he couldn't be prosecuted for any of these activities because these were activities that took place while he was president of the United States, and that a sitting president should have absolute immunity from any criminal prosecution. And therefore, the entire indictment had to be dismissed. The Supreme Court, in a 6-3 vote, decided that the president does in fact enjoy absolute immunity in some respects, enjoys no immunity in certain other respects, and then, as you'll see when I get more deeply into this, may or may not have immunity on certain sort of middle activities. The vote was 6-3, and it followed the current ideological division between conservatives and liberals on the court that everyone has gotten quite used to. And so the 6 conservative justices, in an opinion that was written by Chief Justice Roberts, all voted that the president did enjoy a significant degree of immunity. The 3 liberal justices, Justices Sotomayor, Kagan, and Barrett, dissented. And I'll be talking in this case about the Chief Justice's ruling for the majority. And I'll also from time to time sprinkle in some of the counterpoints made by the dissenters. Two of the justices wrote dissenting opinions. Justice Sotomayor wrote the principal dissent, but Justice Jackson also wrote a very powerful and impassioned dissent. But I'm going to mainly go through the majority opinion at the front end of this talk. It's hard to decipher and hard to understand and has a lot of complexity in it. And so I'm going to go through that carefully with you. But I will, after I've done that, also present as a kind of complete piece the counter arguments of the dissenting justices. I told you it was a 6-3 decision. It was for the most part a 6-3 decision, but on one issue, Justice Barrett deviated from the conservative majority and actually sided with the liberal justices on just one issue, one evidentiary issue in the case. I will point that out and talk to you about it. It doesn't matter, though, because the decision of the court was still 5-4 on everything and 6-3 on most things. And so let's talk about the things that the 9 justices all agreed upon, and then we'll talk about where they split and where the differences arose. First, nobody disputes that there is no immunity that a president enjoys from either civil liability or criminal prosecution for unofficial acts. This principle was most famously established in Clinton versus Jones. This is the case in which Paula Jones sued Bill Clinton for acts of sexual harassment and sexual discrimination that allegedly took place when Mr. Clinton was the governor of Arkansas. He allegedly sexually assaulted Ms. Jones in the Excelsior Hotel in Little Rock, Arkansas. She then brought a suit for civil damages against him under Civil Rights Acts and under common law torts. And Mr. Clinton had then, by then, become president of the United States. He argued that he couldn't be sued, that he had immunity from Ms. Jones's suit, at least while he was sitting as president. And the Supreme Court rejected that view. The Supreme Court said, you have zero immunity for things that had nothing to do with you as president, and the suit may proceed against you. And in the Trump case, in Trump versus the United States, the Supreme Court, all 9 justices agreed that the same principle would apply to criminal liability, that to the extent anything Mr. Trump was accused of doing did not involve his official actions as president, but unofficial activity, there would be no immunity. Secondly, all the justices agree that it had already been established in a case called Nixon versus Fitzgerald that the president of the United States enjoys absolute immunity from civil liability for civil damages for any action taken by the president that falls within the outer perimeter of the president's duties. And so if you put the Clinton case and the Fitzgerald case together, at least on the civil side, we know absolute immunity if it's an official act of the president, and official is very broadly construed with that phrase, within the outer perimeter of the president's duties. We know there's no immunity if it's an unofficial act. And that's the lay of the land that everyone agreed upon. And extending that, everybody agrees, anything that Mr. Trump did that was not official, that was unofficial, he's fair game for criminal prosecution. But that's where the unanimity ended. And then the court was very, very sharply divided. So let me first try to describe to you the majority's holding. And in describing it, there are things that are certain. So there are things I'm confident I can explain to you accurately. And then there are some provisions of the majority's opinion that are more opaque, more uncertain, in which there is some doubt as to the meaning of what the opinion of the Chief Justice held. So the court first said that as to any official act of the president, one must first determine whether that official act is, in addition to being official, also an act that falls within the core of the president's executive duties. And throughout the opinion, the court used that word core. So did the dissenting justices in disagreeing with the majority. If you go to exercise, they tell you to work on your core. You go to education, you go to the gym and work on your core. Well, that same concept seems to be critical here. The word core is used interchangeably in the presidential immunity case with the phrase conclusive and preclusive. That's a fancier phrase, but when the court uses those as synonyms, and what it means is there are certain powers the president has that are deemed under our constitutional tradition conclusive and preclusive, by which the court means Congress can play no role in trying to restrict those powers, and the court in this case seems to say the judiciary can play no role in attempting to restrict the president's exercise of those powers. That phrase, conclusive and preclusive, comes from what prior to the Trump case was arguably the most famous and important Supreme Court case ever decided with regard to the presidency. This is a famous case involving Harry Truman's seizure of the steel mills to break up a labor strike during the Korean War. And in that case, called Youngstown Sheet and Tube, it also goes by the name the Steel Seizure case. In that case, one of the concurring justices, Justice Robert Jackson, laid out 3 levels of presidential power. The president acts at the highest level with the most power when the president acts pursuant to a delegation from Congress. The president acts in a sort of intermediate zone when Congress has not delegated power, but has not attempted to also retract power. And then finally, the president's power is at its lowest ebb when the president acts alone, and it relies entirely upon the president's claim of constitutional authority derived directly from the Constitution. And Justice Jackson's analysis posited that there may be some presidential acts that the president alone has the power to exercise, and Congress cannot interfere, and the courts cannot interfere. And if Congress tries to interfere, the president still wins in a constitutional battle there. So that's where that conclusive and preclusive concept came from. The court said that if the exercise of the power is official and falls within the core, the president receives absolute immunity for that. Now, I'll talk in a little bit later as to what kinds of things fall within that core. But the important thing to realize is that there is no criminal prosecution permitted if it's in an official act that falls within the core. So where did the Supreme Court get this? Where did this idea of absolute immunity or any form of criminal immunity come from? The court said it came from 3 sources. First, it cited what it called the design of the framers. The majority opinion has a problem, and that is nowhere in the Constitution does it say the president has criminal immunity. But the court said that doesn't mean it's not there. And although there may not be a sentence that says the president of the United States has absolute immunity from criminal liability, if the design of the Constitution, as it contemplated by the framers, is inconsistent with criminal prosecution, then that's one of the sources. The court, secondly, turned to the civil liability standards that I've already talked about. I already talked about Nixon versus Fitzgerald and civil liability. And the court said, although that was the civil context, not the criminal context, it guides us. It's a factor that influences us. There's absolute immunity for the president's official acts from civil liability. That is at least a factor that should influence our thinking on the criminal side. And then finally, the court borrowed in certain instances from a somewhat different body of law involving the presidency, that body of law that deals with executive privilege. So when I teach constitutional law, I tend to be very precise in not confusing the phrase executive immunity from executive privilege. Executive privilege refers to a less significant concept, but still important. This is the privilege that a president may invoke to keep secret conversations that the president has with advisors within the Oval Office, or to keep from disclosure certain presidential documents that may also arise from discussions that are confidential that the president has with advisors. So executive privilege is an evidentiary privilege to not turn things over. The two most famous executive privilege cases in American history involved first the treason trial of Aaron Burr, so an issue that dates back to the founding epoch in which John Marshall presided over the treason trial of Aaron Burr. Aaron Burr wanted papers from Thomas Jefferson. Thomas Jefferson said, "You can't subpoena me." And Chief Justice Marshall said, "Yes, you are subject to a subpoena, but you're not like an ordinary person, and you have some rights to withhold matters if they would intrude on the functioning of the executive branch." Then, much more importantly and more famously, the Burr precedent would be invoked in the Watergate scandal when President Nixon sought to avoid having to turn over what were known as the Watergate tapes, the tape recordings that recorded conversations he'd had with his advisors. And in the United States versus Nixon, the Supreme Court said there is an executive privilege. It's not written into the Constitution. It's inferred from the Article 2's creation of the presidency, but it's not an absolute privilege. It's a conditional privilege that can be overcome. In that case, the court said it was overcome by the need for prosecutors to have the evidence that was in Mr. Nixon's possession. So those are the places from which the court derived its rules. So it then said, from those sources, we're going to establish essentially 3 tiers of presidential immunity. If it's official, and if it's a core function of the presidency, there's absolute immunity. If it's official, but it's not a core function, it at least gets what the court called presumptive immunity. It could conceivably get absolute immunity. The court, for some reason, didn't decide this question, whether in that lesser area of official but not core, there would be absolute immunity or presumptive immunity. At times, the court's opinion seems to read as if the court is leaning toward presumptive immunity. At other times, its notion of presumptive immunity seems so expansive that it's almost absolute. That's a big part of the dialogue between Justice Sotomayor and Justice Jackson in dissent and in criticizing the majority's opinion. And I'll get into that in a little bit more detail in a minute. So after creating these rules, the court set out to start down the road of applying them. For the most part, what it did is it said, we're giving you the guidelines and we're sending this back to the lower courts to apply these new sets of rules to Mr. Trump's conduct. But it did decide certain things, and then it created some other roadmaps for some of the other things. So let's first take step one. Step one is always going to be Is it official or is it unofficial? President Trump took the position that pretty much everything he did was official. Although in oral argument, and even in the briefs on behalf of Mr. Trump, there seemed to be some concession, which the court mentioned, that perhaps not everything in the indictment was official. The important thing, though, is the court gave guidance as to how the lower courts are going to try to separate official from unofficial. And it said a couple of things that seem to make the definition of official very, very expansive, very much in Mr. Trump's favor. And this is something the dissenting justices really came down hard on. First, the court said, you may not inquire into a president's motive when you make the determination as to what is official or what is unofficial. So this is gigantic. If you and I are thinking about it, we might say, well, what if Mr. Trump was not really acting as president in order to do something for the American people, for the integrity of the election process? What if he just wanted to hang on to office? What if he just didn't want to give up the White House and his actions were purely selfish and purely designed to try to hold office? Wouldn't that motive, wouldn't that corrupt and illicit motive tell us that it's got to be unofficial? And what the Supreme Court said is, you're not allowed to think about that. You're not allowed to take the motive into account in determining whether it's official or unofficial. So that certainly helps the president in a situation where we look at what the president's done and we have a hard time believing that's anything other than a selfish motive as a candidate. That motive is out of bounds in making the distinction. Secondly, and this kind of gets to the core of the whole case, the court said, and the fact that what the president may have done is allegedly criminal, the fact that we're saying that this violates generally applicable criminal laws doesn't render it unofficial. So the president might order somebody murdered. Well, clearly, you and I might think, well, if the president orders somebody murdered and the president doesn't have the right to engage in that order, because surely it's illegal for the president to order the Navy SEALs to go out and murder somebody, wouldn't that mean it's got to be unofficial? Because how could it be official if it's illegal? And the majority opinion says that's completely the wrong way to think about this. The fact that it's illegal doesn't mean it's not immunized. In fact, the whole idea of immunity, the court is essentially telling us, assumes that what was done is illegal. The whole point is, yeah, you broke the law, but you're immune from prosecution under the law, at least as to these core activities. And so that is a profound expansion, if you will, or expansive view of the notion of the level of this immunity. The court then went down the list of things that Mr. Trump had been accused of. And the court said, well, one of the things he's been accused of, we're going to toss right now. The pressure he put on Justice Department officials, the court said, was plainly an exercise of his core authority. He is the prosecutor in chief. He gets to dictate policy as to the Justice Department if he wants. And moreover, he has the right to fire anybody he wants to fire who's an executive branch official within his cabinet. And from that combination of things, it's clear that this is core. So all the allegations that he pressured people within the Justice Department to send bogus letters to the states are out of bounds. That's core. That's absolute. The court then said, we're not going to decide how to characterize any of the other activities. We're not going to decide whether they were official or unofficial, essentially, and we're not going to decide whether they were core or non-core. The most important of these probably were the attempts to pressure Vice President Pence. It seems pretty certain that the attempts to pressure Vice President Pence were official acts. I mean, it's inside the Oval Office. The president is talking to his own vice president. He's urging the vice president to take certain actions. I'm confident that the Supreme Court regarded that as official. More interesting is whether it was core or non-core. And the Supreme Court suggested probably some conversations that the president has with the vice president are core, because we've come to think of the vice president as a kind of second in command to the president, a subordinate to the president that the president delegates duties to and often asks to carry out important activities. So when it's the sort of boss talking to the number two, that may be core. And if that's what the president is doing, then there's probably absolute immunity. But interestingly, the vice president in some aspects is not the subordinate of the president, but is an independent constitutional officer. When the vice president presides over the Senate, because the vice president is the president of the Senate, can cast a tie vote in the Senate, for example, the vice president is not the subordinate of the president of the United States, but is a member of the legislative branch. It's a little weird for us to think of that, but the court's made this clear over the years. And when acting in that capacity, leading the legislature, in this case, leading the Senate, as in that respect, it's not likely that if the president says, I want you to do this or I want you to do that, it's not likely that that's core. That is probably official, but arguably not core, and thus maybe not subject to absolute immunity, maybe subject to only this presumptive immunity. The court said, we're not going to decide that. We'll let the lower courts decide that in the first instance. At the other extreme, there are the calls that the president made and the conspiracies that the president allegedly entered into to pressure state officials to change votes. We all know the famous call with the Georgia Secretary of State, Brad Raffensperger, in which the president said, I need 7,000 votes to change the results in Georgia, and other communications he called the Speaker of the House of the Arizona legislature. He allegedly conspired with others to create these fake slates of fake electors. You can make the argument that those are not even official, because the president plays no role in how Georgia counts its votes. The president plays no role with regard to the Arizona legislature. The Supreme Court didn't say, though, that they might not be official. The court suggested maybe they are official. Maybe the president's still acting as president with regard to a federal election in some sense. I'm almost certain the court would say those are not core activities. And it's very possible that ultimately the court would say those are not official activities. There's also the various tweets, the speeches the president made, the exhortations for people to storm the Capitol on January 6th, to stop the steal. The court seemed to suggest that those speeches to the public were official, because when the president speaks to the public, the president's speaking from the bully pulpit as the president, but probably not core. A few other points that are critical to make. In an additional kind of bonus section of the opinion, this is the section where Justice Barrett left. She left the conservative majority. The court made an additional ruling that in the real world could have a huge impact on these prosecutions. The court said that not only is the president immune for anything that falls within the core, but you can't use the president's actions within the core to prosecute the president for something for which he has no immunity. So, for example, you can't use his discussions with the Justice Department about pressuring states as background evidence if you prosecute him for things like trying to corruptly influence the Georgia vote or change the results in Arizona, even though that evidence is clearly probative of the president's state of mind, of the president's motivation for what he did with the Georgia Secretary of State or with the Speaker of the House in Arizona, it's out of bounds as part of the case. And the court's reasoning was, if we let it in, then there's a danger the immunity we've created will effectively be eroded, because although technically he's not being prosecuted for what he did at the Corps, what he did at the Corps is basically being used against him, and that would undermine the very immunity that we are trying to create. Last issue, which I'll talk about in greater detail when I get to the dissents, involves this notion of presumptive immunity. What does presumptive immunity mean? It's not absolute. Well, what is it? And the Supreme Court seemed to indicate that it's still extremely broad, that the president would prevail even under this lesser notion of presumptive immunity if the criminal prosecution posed any danger whatsoever to the exercise of the executive branch authority. The court the majority opinion ended with two sort of moral tones. It said, we're not saying the president is above the law. The president is subject to the law. No person is above the law, not even the president. We're not saying that. The court repeatedly insisted it was not saying that, pointing to things like there's no immunity for unofficial acts, and to the notion that there may be only presumptive immunity as to those non-core acts. The court also said, one of the reasons we're doing this is we don't want a world in which former presidents are being prosecuted by people that later came into office, because this will create a kind of revenge cycle. And the court pointed out that a number of the framers were concerned about this. George Washington talked about it. And one of the reasons you've got to have this immunity, the Supreme Court said, is to keep people who are later being scrutinized by someone who was a political opponent from going to jail or being threatened with jail for things that they did while they were president. And we don't want this back and forth that would over time significantly erode the office of the presidency. So I'm going to talk a bit now about the dissenting opinions before I move on to the other cases that I want to talk about. Justice Sotomayor, in a very long, very detailed opinion, said the Supreme Court majority paid lip service to the notion that no president is above the law, but it's only lip service. The reality is you've made the president above the law. Justice Sotomayor said, first, the constitutional text is on my side. Unlike the one immunity that the Constitution clearly does provide, the immunity for legislators for things they do in their legislative capacity, it's called the Speech or Debate Clause. There's no similar clause granting immunity for the presidency. She says the framers knew how to do it. They did it for legislators. They didn't do it here. It means it doesn't exist. She also pointed to the fact that at the time the Constitution was created, there was criminal immunity in the state constitutions of a number of states for governors. She said, so they knew, they had examples of how to create the immunity if they wanted to, but they did not do it. She points out that the impeachment clause is a textual provision that clearly says the president can be prosecuted. So the impeachment clause says that the conviction on impeachment cannot send you to jail, but you're nevertheless later subject to prosecution. So of course the Constitution didn't imagine there'd be criminal immunity, because the impeachment clause itself contemplates it. She drew a lot from history, secondly, pointing to passages from the Federalist Papers, from Alexander Hamilton, pointing to other passages, including some passages from the convention debates from John Madison and Charles Pinckney and others, saying that historical experience clearly shows the framers didn't contemplate immunity. She also brings up later historic practice. and other instances in American history in which the issue has come up and how it seemed to be clearly understood there was no immunity. And her strongest example involved Watergate, which I mentioned before, when President Nixon decided to resign the presidency because he knew he was facing impeachment and conviction in the Senate. As he resigned, when he stepped down from office, Gerald Ford became president, and Gerald Ford pardoned the president. And it makes no sense, Justice Sotomayor said, that President Ford pardoned President Nixon unless President Ford thought, and President Nixon thought, that otherwise the president would be exposed to criminal prosecution. Justice Sotomayor argued as well that the Nixon versus Fitzgerald civil immunity is not the appropriate guide for criminal immunity. She said it is true that it was important to establish civil immunity, but one of the reasons for that is that it's so easy to bring a civil suit. Thousands of people that claim they might be wronged by a president's actions could be suing the president before, during, or after the president leaves office. It would be completely, it could get completely out of hand numerically. But criminal prosecutions are going to be extremely rare. First, presidents don't usually commit crimes. Second, it's a big, heavy thing to bring a criminal prosecution against a president. And there are all these defenses the presidents have. Professional prosecutors have to make the decision to do it. It's extremely rare. But most importantly, Justice Sotomayor said, the public interest in the civil context isn't that strong. It's not such a big interest on the part of the public to whether a privately wronged person gets to sue the president or doesn't get to sue the president. But when the president commits a crime, particularly a conceivably heinous crime, there's a huge public interest in the enforcement of criminal law. And on this point, Justice Jackson wrote a very strong reinforcing opinion that said there should be no immunity. If the president commits a crime, the president should be liable as anybody else to prosecution. The president has a zillion defenses, like anybody has defenses, has all the protections of the criminal justice process, got the protections of a jury, can challenge certain indictments to claim that they're not violations of the law, or that there are other affirmative defenses the president might interpose. But there should be the idea of immunity moves the decision over accountability from where it belongs, which is with the Congress and the courts, to essentially the Supreme Court itself. I better move on. I've given you a huge amount to think about with regard to the presidential immunity matters. The other three things I want to talk about, I can talk about pretty quickly. I do think it's going to take the rest of the hour. I will enjoy your chat questions if I can find them or follow them as best I can. A couple quick postscripts though before I leave. There was a concurring opinion in the immunity case by Justice Thomas. And Justice Thomas took the position that the entire case had to be dropped because the special counsel, it was illegally appointed. Justice Thomas said the attorney general can't just pick a private citizen and make that person a prosecutor. Congress has got to create the position in the first instance. Congress has never done that. And so the entire special prosecutor system here is impermissible. And pointed to the fact that there once was an independent prosecutor law. It lapsed in 1999. And so the entire thing is void. In the Mar-a-Lago classified documents case, the federal district judge in that case agreed with Justice Thomas and has dismissed that case on the grounds that the special counsel cannot exist under our system. That's a decision by Judge Eileen Cannon. That case is now on appeal to the 11th Circuit. I think whichever way the 11th Circuit rules, that issue is likely heading to the Supreme Court again. And postscript number 2, to try to streamline the case in light of the Supreme Court's immunity opinion, Jack Smith has filed a superseding indictment that tries to take the impermissible stuff out of the case so that only things that are either unofficial or official but not core are left in the case. The first hearing on that was last week before Judge Tanya Chutkan. She made it clear she doesn't buy the argument that the special counsel is impermissible. She said DC Circuit opinions already make it clear that it is. So she disagreed with her federal district judge colleague in Florida, Judge Cannon. And then she asked for briefing on the levels of immunity. That will probably take months before that can be finished. And whatever she decides in that case, there'll be an appeal to the DC Circuit and appeal to the US Supreme Court. So it's hard to imagine that we'll know the bottom line on Mr. Trump's immunity for a year or 2 years from now. Of course, if he were to become elected president, he could simply order the federal prosecutions ended, and we'd never have resolution of those issues. So now quickly, I'll go through the other 3 cases I want to talk about. They're not nearly as complicated. First, Trump versus Anderson. This is the case that arose from Colorado's disqualification of Mr. Trump from the ballot. The Colorado court invoked Section 3 of the 14th Amendment, the so-called Insurrection Clause. Most of us as lawyers or law students, we study the main body of the 14th Amendment. That's Section 1. It has important guarantees like the Privileges or Immunities Clause, the 14th Amendment's Due Process Clause, most important, the Equal Protection Clause. And we study Section 5, that one sentence that says Congress shall have the power to enforce the provisions of this article by appropriate legislation. Rarely has anybody studied Section 3 because it's so rarely in modern times been an issue. Section 3 disqualified from federal office persons who participate in insurrection or rebellion, and it was targeted at the Civil War and was designed to make sure that persons who participated in leading the Confederacy could not then get elected to state or federal office and in effect come back into power. Congress has the power under Section 3 to override the disqualification by a 2/3 vote, so it can remove the disability. But in the absence of that, somebody like Robert E. Lee could not, become a senator from Virginia. The state of Colorado, through its courts, reasoned Mr. Trump participated in insurrection or rebellion on January 6th, and he's therefore disqualified. In a 9-0 opinion, the Supreme Court unanimously ruled that Colorado could not do this. And all 9 justices were in agreement that we cannot have states enforcing the Insurrection Clause as to federal officials, as to federal offices. That would turn the states in charge of the federal government, which is a flip, basically, of the normal way we think of our federalism, and it could create chaos and a patchwork. One state might disqualify Kamala Harris, another state might disqualify Donald Trump. We'd have the states skewing the Electoral College map, and we can't have that. So they all agreed on that. The disagreement came with this issue. If states can't enforce the Insurrection Clause, who can do it? And this is where the court then split once again on ideological grounds. 5 of the justices, 5 of the conservative justices said only Congress can enforce Section 3 of the 14th Amendment by using its Section 5 power. So Congress has to pass the legislation that is used to disqualify an alleged insurrectionist, and that's the vehicle that has to be used. Four of the justices, the three liberals, and on this, again, Justice Barrett, kind of moving a little bit more to the liberal side here than the conservative side, said, you didn't need to decide that issue. You should have just been quiet about that. It's not at all clear that only Congress can enforce the Insurrection Clause. Maybe there are other federal officers that could enforce the Insurrection Clause. Maybe federal courts could enforce the Insurrection Clause. You should have just kept quiet about that. Effectively, by doing what you've done, you've given President Trump a complete hall pass on the Insurrection Clause here. So the court split on that issue, but clearly it held a state acting alone cannot disqualify a candidate from federal office, including the president, on grounds that the president participated in insurrection or rebellion. Last two cases I want to talk about could have huge impacts on the coming election. First, there's the problem of the faithless elector. So although we always think of ourselves as voting for president and vice president, voting for either Kamala Harris or Donald Trump, as you know, in fact, what we do when we go to the polling place within our states is vote for a slate of electors. And every state has a designated number of persons in the Electoral College. Every state gets at least two for each of its two senators. Small states like Vermont only get one because they have one member of the House of Representatives. Large states like California, Texas, Florida, Illinois get 30, 40 Electoral College votes because they get one for every member of the House of Representatives. What happens if you vote for your slate of electors and the Electoral College meets and the electors you voted for don't vote for the person you thought you wanted them to vote for? This is called the faithless elector. So let's say California votes for Kamala Harris, but let's say one elector in the state of California decides, I'm not going to vote for Kamala Harris. I've changed my mind. I'm going to vote for Mr. Trump. What happens when there's a faithless elector? Has it ever happened? Yeah, it's actually happened 90 times. There have been 90 Electoral College votes cast since the founding of the country in which the person cast a vote for somebody other than who the voters thought were going to get the vote. What can states do about it? Well, it turns out that there's a patchwork among the states. Some states automatically cancel that Electoral College vote and substitute the correct vote. So let's say you're in a state in which all the Electoral College votes are supposed to go to the winner of the popular vote, Arizona. And let's say Kamala Harris wins Arizona. But let's say there's an elector in Arizona that is stealth, is convinced, is pressured, and decides to switch a vote to Mr. Trump. Well, in some states, the state itself automatically cancels that vote and substitutes the correct vote, if you will. There are some 14 or 15 states that do that. 38 states put some kind of pressure on the electors to vote for whom they're supposed to vote for. Many states require you to take a pledge. You have an oath that promises you will vote for the person who you purport to be representing. In some states, there are fines. In some states, there's criminal prosecution that can attach if you switch your vote, if you're a faithless elector. In 2020, in a case called Chiafalo versus Washington, the Supreme Court of the United States upheld the power of states to punish faithless electors and to thereby put pressure on faithless electors to vote for whom they're going to vote for. Does that mean that they always would? Well, not necessarily. Because if the state doesn't automatically cancel the vote, the faithless vote might still count, even though that elector is fined. The fine in many states is $1,000, or even though that elector might face some jail time. And you could imagine a bizarre situation in which someone would say, I'm going to take the fine, I'm going to switch my vote, And in a close case, if the Electoral College vote were to be, 269 to 269, or, 2 or 3 faithless electors could determine the outcome of the election. There are some states that have no rules involving the Electoral College at all in faithless electors. So there is no legal requirement that the elector vote for whom he or she was supposed to vote for. And that includes some big consequential swing states. It includes Pennsylvania, for example, Georgia, and there are a number of other states that are swing states where you may take a pledge, but there's no enforcement mechanism. That includes states like Wisconsin. If you're curious, Vermont is one of those tough states that makes its 3 electors vote for who they're supposed to vote for, and itself will cancel the vote and substitute the correct vote in the case of a faithless elector. I'll end with one final decision that the Supreme Court decided 2 years ago, a case called Harper versus Moore, Moore versus Harper. And it's enormously important because it lays to rest what had been an uncertain question since the famous opinion in Bush v. Gore. Bush v. Gore was the famous dispute over who had won the state of Florida and whether there should be recounts in the state of Florida. If Florida went to Al Gore, Gore would be president. If Florida went to George Bush, George Bush would be president. And Bush versus Gore raised the possibility that only a state legislature can decide the questions of where a state's electoral college votes go. It was important there because the Florida Supreme Court had made some moves to order recounts, and the Florida Supreme Court seemed to be overruling the Florida legislature on that. And it raised the question of whether the Constitution, which has an electors clause and an elections clause, both of which give state legislatures power to decide the manner of choosing electors within a state. By the way, the framers spelled the word choosing, C-H-U-S-I-N-G. They had a spell check back then. In any event, the question was whether a state Supreme Court could override a state legislature. This was also important in the 2020 election, which was, remember, during COVID, in which the Supreme Court of Pennsylvania overrode certain Pennsylvania state legislative provisions to open the door for certain kinds of absentee voting and when votes would be counted and so on. There had been a conservative intellectual legal theory backed by the conservative justices in Bush v. Gore and very strongly advanced by some conservative law professors and people that, for example, were strong advocates in the Federalist Society, that the Constitution's provisions make state legislatures alone those who dictate policy here. Why would this be important? Well, let's imagine a state in which there were some shenanigans, arguably, in which the state legislature maybe did some things that skewed the vote from one side to the other, and the state Supreme Court thinks that that's impermissible. The state Supreme Court says, you can't do that under our state laws, or the state Supreme Court says, you can't do that under our state constitution. What happens in that situation? And in a very interesting opinion, the Supreme Court in the Moore case said, it's not exclusively the province of the state legislature. State Supreme Courts exercising judicial review, just as we exercise judicial review under Marbury versus Madison, can override a state legislature's decision. The framers, when they created the Electors and Elections Clause, already knew about judicial review. It existed even before our decision in Marbury versus Madison. And when they gave the states this power, they gave it to the entire state constitutional apparatus, including whatever roles the governor might play, the state legislature might play, or the state Supreme Court might play. Well, I apologize that I didn't have time to take your questions. I know there have been all kinds of interesting questions in the chat. I will do the best I can to get back to folks in the chat. But if I don't get back to you, why don't you feel free to email me and I'll be happy to provide answers to you. I hope it's been interesting as we all watch as citizens the coming election unfold. Take care, everybody, and have a good evening.